Yes, shall be funded.
Ms. Joe, how do you want to proceed in this file today?
My client would be accepting an offer to second offense DUI. She's accepted into the Sobriety Court Program in Sheboygan County, which is her residence. And I have that in the court today.
Sure.
And I've talked to the prosecuting attorney out there. She has been accepted. I know these little memorandums are difficult in terms of the boxes we're supposed to check because every county wants them done differently. So we didn't really check the boxes. So whatever boxes that court needs us to check or this court needs us to check.
And she told me she's gonna amend it too. She had amended it, so
We'd
she's
like-
gonna get that out, so.
We'd like to enter the plea and then have the memorandum adjusted as necessary.
Yeah, it looks like judges in Sheboygan signed it wrong. So we may have to have this
Amended.
redone.
I brought it just for verification that she was accepted into the program, so we could do the plea this morning, and I had written verification of that I could present to the court.
Did you want this back? This
Yes,
looks like
thank
an
you, Your
original,
Honor.
So,
I appreciate it.
all right, the only question I have is the plea being entered to the third, and if she successfully completes the second?
It has to be entered as a second originally. If she's unsuccessful, we can withdraw the plea and switch it to a third, but I think she's gonna be successful and that's the way they do it there. I did ask those questions and that actual answer, so.
All right, Ms. Sunday, have you had an adequate opportunity to talk about this agreement with your attorney?
Yes,
Is that how you wanted to proceed today?
yes, Your Honor.
Raise your right hand, please. You solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Your Honor.
Ms. Sunday, are you currently on any kind of probation or parole?
No, sir.
You understand that if you were to not successfully complete the sobriety court program, that you could be subject to the maximum penalty or a OWI second, which is up to 1 year in jail. You understand that?
Yes, Your Honor.
With that in mind, what is your plea charge?
I'm guilty, Your Honor.
Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. The right to testify at a trial yourself if you want it. You understand all those rights,
Yes, Your Honor.
and you understand that you're going to be giving up and waiving all of those rights.
Yes, sir.
Has anybody threatened you with it?
No, Your Honor.
Has anybody threatened you with anything to get you to enter this plea today? Has anybody promised you anything?
No, sir.
Is it your own free choice to enter this plea?
Yes, Your Honor.
Are you pleading guilty because you are actually guilty?
Yes, Your Honor.
The information I have indicates this happened back on February 9th of 2025. Is that the correct day?
Yes, Your Honor.
On that day, had you been consuming alcohol?
Yes, sir.
After consuming alcohol, did you operate a motor vehicle on County Road 612 here in Crawford County?
Yes, Your Honor.
Did you have any blood or breath tests to determine the level of alcohol in your system?
Yes, sir.
Do you know what that was?
0.19.
Okay. Do you have any reason to doubt the accuracy of that test?
No, sir.
Had you consumed enough alcohol that you believe that your ability to operate that vehicle normally and safely was impaired?
Yes, sir.
Have you consumed enough alcohol that you believe you were intoxicated at that?
Yes, Your Honor.
Had you previously been convicted of operating while intoxicated in November of 2021 in the 91st District Court?
Yes, sir.
Ms. Polk, are you satisfied with the factual basis?
Yes.
Ms. Polk?
I am satisfied, Your Honor.
Counsel, are either of you aware of any threats, promises, or inducements other than what's been placed on the record?
I am not, Your Honor.
No, Your Honor.
Are you both satisfied that the court has complied with statute and court rule?
I am not.
Yes, Your Honor.
On Sunday, the court finds that your plea is knowing, voluntary, and accurate. Court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. It's important that you stay in touch with your attorney between now and then. You're going to meet with the probation officer briefly here today to set up sentencing review. Do you have any questions?
No, sir.
Thank you. That's all.
Thank you, Your Honor.
Thank you, Your Honor.
Wit, this is file number 255480. The record reflect that Mr. Witt is present here in the courtroom today. This is the date and time set for sentencing. Mr. Witt, did you have an adequate opportunity to go through the pre-sentence report and talk to Mr. Thompson about that?
Yes.
Mr. Thompson, are there any additions, deletions, or corrections?
No, Your Honor. Thank
Are there any challenges to the report?
No.
Do you have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to this morning?
No, Your Honor.
Anything on behalf of the people for allocution today?
You know, this is one of those anomalies where you see somebody who is 36 years old with no criminal history, no juvenile history, no misdemeanors, really no interaction with law enforcement at all throughout his life, and then makes a bad situation of, you know, drinking and driving at a .214 into something much worse by his own behavior. I hope that he takes this seriously. I think the recommendation is appropriate, and I hope that we don't see him again. Thank you.
I agree, Your Honor. I was working held that evening he behaved badly, and he's very ashamed that he regrets it very much. I think the court does have to put it in the proper context, which is 36 years old, good job, sterling track record, no problems with law enforcement, no issues. He got drunk that day and made him the idiot. And it was idiotic to be driving at a .214, and then it was idiotic to be not immediately complying with the police, and that's on him. That's the mistake he made. I do want to just put in context for the court. He had a surgery just a couple weeks earlier. He's got a problem with his bone on his hand. It's got him off work, caused that surgery. When he was being an idiot and he was not immediately complying with police officers and they started to restrain him, they caused him a lot of pain by the way they were restraining him, because he had just recently had a surgery on his hand. And I think that's part of why after that he did, you know, kind of react physically. But he put himself in that circumstance, Your Honor. So I don't want you to think I'm trying to blame police officers or anything like that. I am trying to explain part of what happened that day was he did experience a lot of pain in his hand where the officers would have known that that would have been such a sensitive spot for him. Having said that, Your Honor, having said that he acted inappropriately that day, I hope none of us get judged solely on the worst day of our life. And for a 36-year-old guy, you know, I think this can end up being more of a wake-up call for him. I think this can end up being the worst day of his life and something he improves from. I did want to sort of follow up in the substance use and treatment part of this report. It states that he told the probation officer he didn't think he had a drinking problem. I've talked to him some more. I don't think that's what he would say today, and I don't think that's accurate. And what I tell a lot of my clients is, you know, you can debate about the semantics, but you have a problem, and it's from when you were drinking. So you have a drinking problem as far as I'm concerned. I mean, he's got a huge problem. He's before a circuit court judge today. He's got a huge problem in his life now, and it was caused by his drinking. So he understands that's a drinking problem. That's a problem in his life from drinking, and drinking, you know, objectively too much, 3 to 4 times a week is too much to drink. Being at a .214 while you're driving is objectively drinking way too much. So he now has, it's now right in front of him. And he sees that, and he's taking that seriously. And he is going to AA, and he's given me this AA sheet, Your Honor, as he's trying to come to grips with and learn about what's happened to his life and what could happen if he doesn't arrest and change this. So he got put on bond conditions to not drink alcohol. He's not drinking alcohol. He's learning a lot. I don't think he's all the way through recovery. Certainly the court talks to people who've been to rehab 6 times and they, know all the language real well. He doesn't know all the language real well, but he knows he has a problem. And he knows he needs to face consequences today and own up to it. And he knows he needs to use this as a learning opportunity to not have this happen again, not put himself in such a terrible position because he acted so stupidly. And he does want to apologize to the court. He regrets what happened. Again, this is a guy with a good job, with really good family support. I think he'd be an excellent candidate for probation to do well. And this might be a situation where the court can hold his jail time in abeyance because he's going to let us know how this is going to do. He's going to be under a microscope. He's going to have to be sober. He's going to have probation officers and people watching him. And if he can turn this thing around, Your Honor, I think that we can chalk this up as, thank God nobody was hurt. Thank God it wasn't worse. And maybe he learns from it. And if he doesn't, then, the court's got all kinds of sanctions they can impose on him. So ask the court to consider jail time in abeyance, consider probation on this matter. Thank you.
All right, thank you. Mr. Witt, anything that you wanted to say?
Yes, I just want to start off by apologizing to the city of Grayling, everybody, the officers, you guys here, putting everybody in the state on the way up in jeopardy because I was drinking and driving on the way. And I drank a lot before I got in the car, before I came up here. I drank on the way up. I shouldn't have been doing shots on the way up. It's just a terrible idea. I mean, it's just one thing led to another. I don't think my attitude was very good. Going to AA, I've kind of learned a lot more about me and drinking and everything else, being away from alcohol, I've definitely learned that I've calmed down quite a bit. I've been so wound up. I haven't been working because my hand's been injured. And, I just, it's kind of, that drinking thing's been getting out of control. I chose to make a poor decision. I made more bad decisions with everything. I just wanted to say, or I just want to apologize to everybody. I made a mistake. I own up to it. And, I'm sorry.
Read through the report, so I'm familiar with you, your background, your circumstances generally, as well as the details of what happened during this incident. I think Mr. Thompson summed it up really well. We've indicated it as well. That it's probably something that's been coming maybe for a while. And this all came to a head on this particular day. Certainly the court has concerns about public safety. You indicated yourself, you really did put everybody in danger, including yourself. By driving in the condition you were in, that's an incredibly high blood alcohol level operating. What is basically a bullet going 55 or 60 miles an hour. And it's just by sheer luck. And I'm glad to hear that you are getting some treatment, that you're taking this seriously. You're going to AA. And it sounds like you're discovering maybe some things that maybe this has been a problem for a while. You just didn't see it as that. This is made it more apparent. So getting help with that is going to be really important for you going forward to avoid having more trouble to move on from this instead of this being like the first time with many. That's not what you want. Certainly not what we want as a community.
No, I definitely would like to be my last time.
Yeah.
I'm gonna make it my last time.
Getting involved in AA, getting some therapy, some help. It's the kind of things that are going to prevent it from happening again. They're not fun to do. It's not a pleasant thing, but you're going to have a better way to do that. In terms of the resolution of this, based on your employment, your individual circumstances, I don't think that probation is a good option here. Regardless of the probation, I do think that a short jail sentence is appropriate as a punishment, as a deterrent, so that you understand that this is just not acceptable behavior and there's a consequence to that. The guidelines here are 0 to 9 months, so the court could sentence you to up to 9 months in jail. I don't think that's appropriate, given the factors that Mr. Thompson outlined, your lack of prior history, and so forth. And that's why I think the recommendation here is is well crafted. It provides a degree of punishment for you. And again, hopefully deterrence so that a stay in jail is gonna really drive home the point that this is not the direction that you wanna go in your life. So the court is going to sentence you to the Crawford County Jail for a period of 30 days. You do have credit for 2 days served. It's going to order restitution in the amount of $240.98. That's payable to the Crawford County Clerk to be dispersed to the Crawford County Sheriff's Department. Crime victims assessment of $130, court costs of $325, attorney fees of $350, OUIL testing reimbursement of $150, DNA testing fee $60, and $118 state costs. That as to both counts 1 and 2 to be served to each other. Mr. Thompson, was there something else that you address?
I was just checking to make sure we had 2 days credit.
Yes, 2 days credit. You do have the ability to seek an appeal of the sentence, Mr. Witt, Mr. Thompson, if you can have Mr. Witt now.
Thank you. So Mr. Witt, if you initially hear that's not filing an appeal, but it's saying you received these papers, you're going to keep 2 copies. If you wanted to file an appeal, you would use these 2 copies, you would fill them out. Give 14 days to do that, you can take those with you. You're going to end up going with Steve here, okay?
Am I going to jail right now?
Yes.
Is there any chance I may be able to change?
We're gonna have to go with the officer that'll help you